yes, the other one says no.
Mr. Mayor, I believe it's 10 a.m.
Okay. An agenda for my okay. Are you ready? Yeah. I now call the special session of Mayor and City Council meeting at 10:05 Monday, October 1st, City Hall Complex Council Chambers. Will you please call it to order? Will you please rise for the Pledge of Allegiance? Councilman Maldonado, would you lead us in the pledge?
Sure will. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, we're going to go right ahead into the meat, and we've got under 3 discussion items. Number 1, discussion and possible action changing the meeting dates of the regular scheduled meetings of October and November 2018. Mayor, I have a motion to, well, actually, do we have to approve this motion? Or?
Well, I'd just like to explain why I had it placed on the agenda.
Okay, so we'll open it for discussion.
Yeah. Would you please, Mayor?
Okay, we have a motion. Do we have a...
Who made the motion?
No, I just wanted to have a little presentation.
No, I know, but do you want a motion?
Discussion and possible action
move,
changing
Mayor.
we have a motion.
Hey, Mayor.
What date are you moving to, Mr. Reyes?
No, I'm just moving
To open the
that
discussion.
we
Okay.
open it up.
And then we have a second?
Did I get a second?
Second.
Okay, now we're all set. Open for discussion.
Mayor, I have like to see if my colleagues here could help me. This Wednesday, I didn't write down the city meeting, and we're having an Arizona School Boards Association county workshop at Rio Rico High School on that day, and there's going to be some awards presented to myself and Mr. Lucero. So I was asking if we could move the meeting from the 3rd to the 10th, if there's no conflicts there. And also the meeting of November the 7th, several of us, that's the day after the election, several of us are going to be attending the city summit in Los Angeles, and we're leaving Wednesday morning. If we could change that meeting from the 7th to the 14th.
Yes, okay. And we'll check with our city clerk before we go any further.
Okay.
Do you see any conflict there, Mrs. Robinson, on changing those dates? None at all. Okay. So I believe that we don't want to get into where maybe we have a shortfall here. We don't have enough councilmen, especially for that second meeting. So does anybody else want to make any comments on?
Yeah, I have a question, Mayor. The same time at 6?
Same time at
Same
6?
time, just a different date.
Yeah, the time will be 6 unless staff thinks that we need to have a study session or something, but it's 6 o'clock.
The regular meeting. Yes, Mr. Kinchin, would you like to?
Yes, Mr. Mayor, we're anticipating having a study session for the October meeting.
October 10th? At what time?
We haven't determined, but typically around 4 o'clock is when we have them, I think.
So, more the reason that there's another item that
We're anticipating having a study session on the October meeting.
Okay.
Okay. So,
Okay.
so it makes sense to move up those dates, make sure.
That doesn't conflict with anybody, does it? Start a little bit earlier.
Right. We want to have as many as the council on these 2 dates. So, my recommendation would be to go forward with changing those meeting dates if it's okay with staff and I guess with the city clerk. And is there any other comments? Seeing none, I call for the question to approve this motion. All those in favor signify by saying aye.
Aye.
Aye. Any nays? Seeing none, motion carried unanimously.
Thank you, members and colleagues. The second Wednesday of October and September and November.
Let's see, the October would be, what day would be the?
So then our next meeting,
14th,
October the 10th
10th, and then the 14th of November.
and November the 14th.
And same times as normally, except for the study session. Okay, we got that done. We'll go to number 2. Discussion and possible action, withdrawal of mayoral candidate prior to a general election in a charter city. Now, I guess, well, we'll just open it for discussion and possible action. That I have a...
Mr. Mayor, just to include there, also where the vote is nonpartisan. It's a charter city where the voting is nonpartisan.
Yes, and not only that, aside from you know, okay, I guess I would cover our local constitution and everything. So, but on this one, we don't, for the language, in a charter city, like you said, where the vote is nonpartisan. Now, that's not written in there. Does that affect anything? Or can we, at this time, make sure we make a note of it?
I'm a little confused with the inquiry by Councilman Hanesian. Mr. Mayor, perhaps Councilman Hanesian can elaborate on exactly what his inquiry is with respect to nonpartisan elections.
Well, the reason is because there's case law basically referring to partisan and nonpartisan elections. That obviously we will need your opinion on it, or anybody else's that has legal opinion on it, as to what the difference between partisan and nonpartisan is, right? Obviously, in the partisan deal, you have, you know, two parties basically. Let's say the Republicans and Democrats putting in someone to run for that position. In a nonpartisan, nobody runs as a Republican or Democrat or independent or anything. They're all running just as individuals, period. So I think that makes a difference. I think later here you did come up with Catlin a court case, and I think it comes up with the idea of that, and some of the statutes come up with the idea of partisan and nonpartisan. But like I said, as we go along, we can discuss that, and you can go ahead and lead us as to what the situation is. If and not, I bring it up. If it's a question of being partisan or not partisan, hopefully you will bring it up.
Okay. Thank you, Councilman Hanesian. So, in fact, the election held this past August, and that was canvassed this past Wednesday, was a nonpartisan election. Our charter, in essence, calls for the top 2 vote getters to move on to the general election. And so, to answer your question, it was a nonpartisan election that was held this past August. I've laid out my opinion in a memorandum that was passed to Mayor and Council this past week. I gather that there's some confusion with respect to that memorandum as it relates to whether our election or as to whether the issue of allowing a write-in candidate for the primary election, for the general election, is permitted or not.
Could you repeat that again, please?
So I gather that there's perhaps some doubts as to whether a candidate that was not in the top 2 for purposes of moving on to the general election can now proceed as a write-in candidate on the basis of the Catan decision? Because when you mentioned case law, Nubar, Councilman Hanesian, I imagine you're referring to the Catan case.
Yes.
Is there another particular case that you are concerned with other than that one?
Well, basically, I think that case refers to another case. There's Diaz.
The Diaz case.
Case, right?
Very good.
Pima County, yeah. But
Is there another case other than the Diaz case and the Catan case?
No, that's basically the only ones I gathered that were mentioned in the Catan case.
Mr.
Mayor,
Mr. Mayor.
Yes, go ahead.
no, just to make sure that we're clear on all of this, on these two cases, even though they're not really relevant, but the Catan and Tejas case out of Pima County. But my question to you is so that we're clear. We have, and this was analyzed in some aspect in the Catan case, but just to make sure that we're clear here, my question is, why does candidate C, whose candidate C is the third place, why doesn't that candidate automatically move up to the position of B? And if so, if that can't happen, why does the analysis comes in? The write-in, is the write-in available to C, candidate C, and candidate D, or plus anybody else?
Okay. So, if I may take it as they come, Mr. Mayor, if you will, please. So there's a legal opinion by Kathy Connolly from the League of Arizona Cities and Towns with respect to the issue of whether a candidate can move up. Okay, the election, the primary election has been canvassed. The voters have spoken. And the voters opted to have Arturo Arino and Greg Lucero be the two candidates to move on to the general election. That is clear. Nothing can change with respect to that point.
Correct.
Okay? In fact, the case, both Catan as well as the statutory framework underlying that that paradigm, in essence, allows it, and you can't move it. In fact, the ballots have been printed, and Greg Lucero's name will be on that ballot. Okay. The situation has arisen now, as you have pointed out, where there is a petition presented for purposes of one of the candidates at the primary to become a write-in candidate at the general election. That in essence is that scenario, if you will, is not clearly and specifically laid out in our charter. It's just not. And in essence, where the charter is unclear, then you look to the statutory framework in Arizona. And the statutory framework is such that under 312, under section 16312F, it basically where 16312 refers to filing of nomination papers for a write-in candidate. 16312F states that except as provided in section 16343 subsection E, a candidate may not file pursuant to this section if any of the following applies. And under 1, it says, for a candidate in the general election, the candidate ran in the immediately preceding primary election and failed to be nominated to the office sought in the current election. So you would think that under that section, 312F1, the write-in, the third place finisher would not be allowed, and the fourth place finisher for that matter. And you pointed to that scenario as well, wherein Mr. Melendez falls under that section, F1. However, then you look to 16343. And 16343, in essence, states that
Is that D? 16343D?
well, that's one of the something I want to point out. 16344D. 16344D. 16343. Okay, in essence, you have to look at it as a whole.
Okay.
And 16343 under A and then B under A is to be read separately is to be read separately from 16343D or E for that matter. Okay? Under 16343-4, all right, and I would ask that you refer to 16343A4. It states, if the vacancy occurs in a candidate race for a partisan nomination, in which at least one candidate of the vacating candidate's political party remains on the ballot for the vacating candidate's office, the vacancy shall not be filled. The only reason I'm making reference to 16343A4 is because the Catan case makes reference specifically to that section of 343, 16343. The Catan case does not reference 16343D and E. Okay?
So they're just referring to partisan.
That's right. So 16343D and E opens a door to candidates nominated pursuant to subsection A of this section, or a candidate running as a write-in candidate under subsection D of this section. Or a candidate running as a write-in candidate under subsection D of this section may be a candidate who ran in the immediately preceding primary election for the office and failed to be nominated. We have two candidates that failed to be nominated. And this particular section allows them to run in the immediate, even though they ran in the immediately preceding primary election for the office and failed to be nominated. That is my legal opinion, and that is what I have laid out in the memorandum that I passed out last Wednesday, along with these statutes, along with some other pertinent documents that I felt the mayor and council would benefit from as a considered this scenario that the city is having to deal with on account of a withdrawal of a candidate after the primary.
So is there a possibility that a candidate who has officially withdrawn his name from the candidacy, yet his name appears on the ballot, could become the victor of on election night?
No. The case law is clear. You could look at Theus, you could look at Catan, and you could look at those memorandums that I provided to you.
Didn't Theus say that the votes will be tabulated?
The votes will be tabulated.
Uh-huh.
They will be considered nulo or invalid for purposes of the general election. They have to be tabulated, and that is the reason why, with the assistance of our city clerk, I last week prepared a notice to our electors so that they can become aware of the fact that any vote for Mr. Lucero will be considered nulo or invalid.
Null or invalid.
Which is different from voided, because the term void is just technically and legally distinct from nullo or invalid. The terms nullo or invalid are used both in the case law that I've reviewed along with the opinions by Catherine Conley of the League of Arizona Cities and Towns, and other references to
Kathy Conley,
Catherine Conley.
but it's not her opinion, it's the general counsel's opinion. Kathy Conley.
That's right.
That's okay.
She was the assistant director.
Right, she
I
was the-
apologize. It's Lamar Shelley,
Right.
general counsel.
So, Mr. Para, does, Mayor, Mr. Para, do we, when we legally canvass the votes, then, based on your opinion, we do not canvass any votes for the person who has withdrawn?
We did canvass the votes
No,
for the
no.
person that has withdrawn.
Yes, no, but I'm not talking about the primary, I'm talking about the general. Let's say that person receives X votes.
Right.
When the official canvass comes, will his name, will those votes be a part of the official canvass? Because what you're saying with Nulu, how could we canvass it? I just want to make sure, I don't want to talk about this in November, next month.
They will be tabulated.
Okay, I
They
understand.
will be considered invalid.
Okay, but will they be a part of the official canvass of the mayor and council?
They will.
Okay. That's what I don't, okay. With a note that they have, and your opinion of the Nulu,
Correct.
to make sure, okay. Now, on the general election, the results to declare a victor is a simple majority, or are we going back to this 50+1 and,
Is the Turco Kavanaugh?
yes.
Sorry. I'm sorry.
That's all right.
Councilman Verona, please
Now, the
proceed.
question is, on the election results for the position of mayor, is that results based on a simple majority, or is it based on what the primary was, 50% plus one, and if none of them receive it, we have to go to another election?
No, Mr. Mayor, Councilman Verona. Whoever gets the most votes
Simple majority.
wins the election.
Okay, that, I just want to have clarity, because
Correct.
it's come up on some of these things that I just want clarity. Once you issued your opinion, then that's what we guide ourselves by.
That's correct.
Okay. I wanted to make sure of that, and if you could just ask that question. So, as of right now, Mr. Para, has the deadline, when is the deadline to submit your interest as a write-in candidate? When does that expire?
So, $343.
I don't understand if it's 5 days or 28 days.
Allow me to reference the section, please. 343. A vacancy that is due to voluntary or involuntary withdrawal of the candidate and that occurs following the printing of official ballots shall not be filled in accordance with this section. However, prospective candidates shall comply with section 16.312. A candidate running as a write-in candidate under this subsection shall file the nomination paper no later than 5 p.m. on the 5th day before the election. So, no later than the 5th day before the election, you can have a write-in candidate
So, but there's
file
only,
the nomination paper.
but there's only, we can only legally have 2 write-in candidates.
That is correct.
All right. I'm just trying to see here if somebody, if candidate, candidate B withdrew, candidate C has indicated that he's interested and submitted the paperwork, and if candidate D doesn't do it until 5 days before, what is it that you're going to tell the public who is the write-in candidate and when they can start voting for that candidate? Because if he does it 5 days before and the ballots go out on the 10th, I just want to make sure we don't come out with a lawsuit that says, well, you didn't tell them that I was included.
Fortunately, the League of Cities and Towns has provided us with direction
Okay.
so that we can deal with that scenario. And again, as I've mentioned earlier, the city clerk and myself have now provided the the elections, Melinda Bink from Santa Cruz County, with a document that states that that basically informs the public as to the fact that Greg Lucero has voluntarily withdrawn his nomination for the city of Nogales, and any votes for his candidacy at the general election to be held on November 6th will be considered null or non-binding, nulo o sin efecto. The League of Cities and Towns also provides us with a direction on page 18 of the League of Cities and Towns Elections Manual, Municipal Elections Manual. It states, notice of withdrawal shall also be posted at all early voting locations. This is to be posted at all early voting locations and be made available to early voters by providing with the early ballot instructions on a website address. We've discussed this with Ms. Meeks as well. They've informed us that they will upload this onto their website, the pertinent website that's used for voters in Santa Cruz County, and that will be done as I believe as soon as possible. And again, it says voters by providing the early ballot instructions at a website address at which updates to information regarding write-in and withdrawn candidates is available. It is good practice. So in essence, this website is meant to be used in scenarios where 5 days before the election, a write-in candidate walks right into our city clerk's office and informs our city clerk that he wishes to become a write-in candidate. The only notice, well, the notice, we have to inform the public of that. And in order to inform the public of that, we have to do it by following this guidance by the League of Cities and Towns, and having that instruction or having that notice be on that website.
And does the name of candidate C and D appear on that website?
Correct. Right.
Is that the only place it will appear on? It won't appear or just on the website?
It will,
Like along with that notice on the polling places or anything? The writing candidates' names appear or just on the website?
on the website, and again, notice of withdrawal.
His withdrawal, yes.
A website which updates ballot instructions, a website address at which updates to information regarding write-in and withdrawn candidates is available. Let's say the A in our scenario withdraws.
Right.
If he withdraws, we have to inform the public. And the way to go about informing the public is by way of a website along with a notice at each polling station.
Okay. So if A was to, which could happen, if A was to withdraw, it would be up to candidate, at this time, just candidate C. It would be the only legal candidate.
That is correct.
To this point. No?
At this point.
Okay. You're bringing clarity now more to this.
Thank you, Councilman. Thank you for your pointed questions as well.
I just want to make sure if somebody asks me out the streets, I can say, and when they can trust what we're saying and we're all speaking.
But I have a difference of opinion.
Oh, go ahead.
Councilman.
Go ahead. That's what we're here for.
And I believe that the city charter is the reason why we have to dictate how the elections are supposed to be run and how they're supposed to be interpreted. And I don't see why we're getting away from the city charter and going to state law or leagues of cities and town opinions when they don't dictate over charter cities. A lot of times I call them for opinions They're not familiar with the city charter. They refuse to give me an opinion. And the thing is that under the city charter, between 26 and 36, it goes back and forth, not only giving clarity, but you know, what we need to do, but really establishing that if somebody withdraws, there's a written withdrawal, and there's the timelines there, and it goes that the names that remain, in other words, what it's saying, there's supposed to be more than one candidate running on the ballot for the general, and the names of only such candidates who were not elected at such first election as hereinafter provided shall, if proper and necessary, be printed on the ballot to be used in the second election. And if you look at proper and necessary, well, it's necessary to have that second candidate in there. And if you look at 26, any person whose name has been presented under the foregoing sections, which is withdrawal of names from nomination, or in the manner provided for nomination hereinafter, may not later than 28 days before the day of election cause his or her name to be withdrawn from nomination by filing with the city clerk a request therefore in writing, and no name so withdrawn shall be printed on the ballot. And all that was completed before 28 days. If upon such withdrawal the number of candidates remaining does not exceed the number to be elected, then other nominations may be made by filing petitions therefore not later than 20 days prior to such election. And so, if you look at that, it covers this scenario, and under 34 and 36 even, if at any election held as above provided under those sections, there be any office or offices to which no candidate therefore was elected, then as to such office or offices, said election shall be considered to be a primary election for the nomination of candidates for such office or offices. And that's 36, second or general election. So we need to go back to make sure that we have a second candidate like in the primary for the general election.
So are you?
That's what it says here.
No.
And that could be challenged by any resident of the city. It could be challenged by any candidate. And they'll go into the court system.
Right, that's what you...
And
that goes back, I think he's going back to my question of having those two candidates and candidate C automatically going up. And you've answered that.
But going through state law.
No, you've answered it going through the state law, but I've also heard Mr. Parra say that there is weaknesses in our charters as to the elections. That's why you're making reference to state statute versus our charter. Getting back to Mr. Felix, Dr. Felix. How many times did we not talk about revising our charter to make sure that these things are written down instead of dealing with an obsolete charter? But back to you, Mr. Parra. I just want to make sure you're our legal authority here, okay? You're the one who protects us from an individual lawsuit coming against us. That's why we accept your opinion. But I want to make sure that Mayor Doyle's concerns are also answered. And did you previously answer Mr. Mayor Doyle's concern by saying that those statutes, those charter articles that he's making reference to do not have precedence, and you have gone towards state statute instead?
I provided a legal memorandum
Right.
to mayor and council last Wednesday.
And you said that.
And in that legal memorandum, I expressed my concern with the fact that our charter does not have guidance with respect to a candidate withdrawing after a primary. And my opinion was also that Section 26 relating to withdrawal of names from nomination and is to be analyzed and to be viewed in conjunction with an occurrence of a withdrawal, death, or incapacity prior to the primary election. Had candidate Lucero come in 28 days before the day of the primary election, everything that's laid out in Section 26 would have been triggered. That did not happen. He withdrew after the primary. Therefore, I had to look to state statutes for purposes of, as well as legal opinions, memorandums, analysis of case law, for purposes of getting to this conclusion that I've now discussed with Mayor and Council by way of a legal memorandum last Wednesday and by way of my discussion this morning.
Okay, can I
Sure.
see here? I'm reading right out of the city charter. I'm not reading any other document, whether it's from the leagues of cities and towns or state statute. What I'm saying, you know, I hear what you're saying about 26, but at the same time, this, what I read here, brings us back to 26. And that it says that any election held as above provided, there be any office or offices which no candidate therefore was elected, then as to such office or offices, said election shall be considered to be a primary election for the nomination of candidates for such office or offices. That triggers 26, and that's in the general election. That's for the general election. That goes back to 26 and triggers off 26 because 26 is a case scenario of what happened here. And this section here triggers that off. So whoever wrote this knew what they were doing. They put clarity here. It covers, one section covers the other. And that's where we're going to end up in trouble in court. Because we're going to have legal minds looking at it, and they're going to study it, and they're going to see that bridge, and they're going to see that we did not follow the city charter, even in the canvassing or any other procedure that our charter sets out. I think we should have probably stayed away from having the county run our elections and done our own city elections the way we used to. It might be a little more expensive, but in the long run it can be cheaper when we end up making the wrong decision over the city charter. So that's the problem right there, that we're going to now to opinions outside of the city charter when the language in the city charter is covering this scenario.
Well, I don't want to get into, I don't think any of us want to get into a dialogue with you on that, Mayor. You know, there's some sentences there that I concur with you, but I can only rely on the legal opinion. By law, I have to rely on the legal opinion of our city attorney. That's all I have. Now, if somebody disagrees with him, well, you have the right, I have the right to seek relief from Superior Court. I have that legal right. But right now, I have to rely on Mr. Parra. He's the city attorney, to give me his opinion. I don't need to summarize your opinion, but I know that you're moving forward on this. There's a dispute with one part of the charter with that, but I think the only thing that I hold up is that the partisan versus the nonpartisan, and we are a nonpartisan election. So unless you change your mind, Mr. Parra, or anything, I see that we're going to move forward, and there's two individuals who have the legal right, according to your opinion, to participate in the race for mayor as write-in candidates. And if there's something, and that Mr. Lucero's, the candidate who has withdrawn, none of the votes that are cast for him, because he is still on the ballot, are considered null. And that his results will be a part of the official canvassing of the ballots. And the winner of the election is the one who receives a simple majority. If I've said anything incorrect or misinterpreted you, Mr. Para, please tell me.
So the situation that I understand, Councilman Varona, Mr. Mayor, I understand your opinion with respect to the reading of Section 26 and Section 36. And again, I've reviewed. I've reviewed the pertinent case law where these types of situations have arisen. I gotta tell you that I have not found a case on point in Arizona that deals squarely with this fact pattern. But there are cases that give us guidance in situations such as this. And we also have memorandums that have been prepared to deal with withdrawal of candidates, death of candidates, and candidates that have become incapacitated. And but I just want to make it clear that there is a huge distinction to be made. And we started this whole discussion with the Catan case. Mm-hmm. And the Catan case is the most recent case that I found that is somewhat on point, but not with the exact same fact pattern.
2009.
And this 2009 case, the analysis that was undertaken by our appellate court led them to the conclusion. I don't know if you have it in front of you, and I took the time this morning to highlight a particular section that I found pertinent and important for our analysis.
Is that number 5 on the last page, the footnote?
That's right.
Yeah.
So if you all look at that footnote, it says we recognize that Catan qualified as a write-in candidate for the general election. Our discussion relates only to his eligibility to be listed as a candidate on the general election ballot.
That's all.
Okay? The whole discussion revolved around that councilman in Prescott wanting to be on that general election ballot. And our appellate court has spoken. Yes, we do not have a Supreme Court, an Arizona Supreme Court decision on point. But yet we do have some guidance. And the guidance comes from Deas, the Superior Court. And in that case, when it came down to the issue that Mayor Doyle has brought up, which is the issue of should that candidate move up on and be on that ballot. And there is a memorandum that I passed out. It's an old memorandum, 1987, by Lamar Shelley, General Counsel for the League of Cities and Towns. Actually, it's older than that. It's a decision. It's a memorandum by Walter Reynolds, the city attorney for the city of Chandler. And in his memorandum, and I've given a copy to all of you as well. If you look at the last page, actually the second to the last page is there's a discussion there. in essence, it's the paragraph right in the middle talks about how the Arizona Supreme Court, the decision by the Arizona Supreme Court is that all votes in an election must be counted. All the elections, you know, in order to bring about an automatic substitution of the candidate receiving the next highest number of votes, in this case, in our scenario, Mayor Doyle, it would be necessary to literally throw out the votes of the candidate who died in that case, but in our case, who withdrew, who died, became incapacitated, or withdrew. The Supreme Court says that this cannot be done, and those votes must be counted in order to determine the overall results of the entire election.
No.
So I would
What are you
reference.
talking, are you talking about nonpartisan? Are you talking about the city charter? Or chartered cities, or what? Because according to our charter, we're supposed to stick with it. And now again, we start going out of our, in other words, we have nothing to do with the county. They're just a vehicle for the election. That was it. Their laws don't apply to city charter laws. And that's what I'm seeing is that we're getting away from the language that's in our city charter and basing it on an actual partisan or state law. And that's where we leave ourselves open for a legal challenge. And the city has a motive here because they don't want to spend more money on doing their own election. And I don't blame the county on not wanting to reprint the ballots because according to their state law, they don't have to. But yet, city charter demands that if whoever withdrew their name states it here clearly, that we're supposed to take him out of the ballot with the new ballots and then go and put the other candidate. So all that you said doesn't apply to our city charter. And that's where the problem is.
Mr. Parra, what supersedes, our charter or the state law?
We have to follow our charter, one. If there's no language in our charter that clearly directs us with respect to a scenario that comes up, and believe me, those scenarios come up in all sorts of ways, and it's not necessarily election related. But you know, we have to look to state statutes. We have to look to state statutes when we just don't have the answers in our charters.
And on the summary that you point out on the Court of Appeals on Catan, if you look at the discussion on point 2, the court gives you insight into it when they say because a court's jurisdiction over election contest is purely statutory and not a matter of common law. If no statute exists granting the court's jurisdiction, the court has no jurisdiction to act. So it's just based on statute. So if there's nothing that we have for us to act in city charter, then we turn to state statute. If it's not on state statute, then people turn to civil rights and the federal statutes. But this clearly explains to us that the court is not so much taking into consideration the common law, but just what does the statute say. And I think that brings relevance here to Mayor Doyle's concern though too. I mean, it's hard. His points I can see, but in the lateness of the game, I have a tendency to go with your opinion. I just can't see us going printing the ballots and all of that at this time, having our own election or anything like that. Even though I will say that when we originally started, when we switched from having March, we used to have our city elections in April and May. And I was on the council when we decided that we would turn our elections and be governed by the statutes of the state of Arizona, and we would run our elections according to the state of Arizona to avoid the duplication of having an election in April and May and then having another election in September and November. Points well taken, but I at this point I have to rely on the city attorney unless a court of jurisdiction overturns that opinion. If that happens, then that's a different story.
Councilman Barahona, Mr. Mayor, I mean, with all due respect, I worked hard on this opinion. I've reached out to my colleagues, the City Attorney Association, the Arizona City Attorney Association. I've reached out to the Secretary of State's office. I understand there's a lot of confusion in the community, and obviously there's a difference of opinion here, which I'm respectful of, but I think I've laid out the opinion as well as I possibly can, and if there is litigation to follow, all I can tell this honorable council, mayor, I'm gonna stick to my opinion and again continue to advise the city consistent with these opinions.
Yes, Councilman.
Mr. Carver, could you just go ahead and give us your opinion again, exactly what it is? I know it's in writing in here, so much paperwork, but give us your opinion exactly as it is.
Sure, and I'll try and just give a summarized version of it. My opinion is that Section 26 of our city charter does not apply to general elections. The scenario where there's a withdrawal 28 days that has to be done 28 days before,
And it was.
is applicable to primary elections, not general elections. My opinion is that the need to have a candidate who was not the successful candidate at the primary election on the ballot is not consistent with legal opinions, with our case law as well as our statutory law. And my opinion is that under Section 16.312 as well as Section 16.343 D and E, that candidate that was not successful in the primary is allowed to run as a write-in candidate. That's my opinion.
Now, have you concluded, Mr. Councilman Anderson?
Yeah, for the moment, yeah.
Just a question, so the time frame is reducing. I just want to make sure we're clear on one thing. If a lawsuit is brought based on your opinion and the court overturns that, what is the time frame that, because of this, that who's going to make the decision of that? We go to the appellate court immediately. Is it the city manager or is it the mayor and council? Because there will be little time in case this happens, little time, that the courts take election deals right away. They move to the front of the calendar. I just want to know who's going to make that decision whether we would appeal or not.
First of all, with respect to your first question, the city attorney is authorized and has the charter authority to dictate all legal affairs
That's true.
that the city confronts, whether it may be something that's in litigation or something that is to be litigated or a contract dispute, everything. City attorney is supposed to dictate the legal, or not dictate, but in essence, conduct the legal affairs of the city. I believe that's the language in the charter. It's very clear. So in essence, I would make the decision as to what steps need to be taken in order for this body, because I represent this body.
Right.
I don't represent you individually.
Right.
And when this body, and when someone is challenging this body, then I'm responsible for providing the legal advice that's necessary to this body so that the city is protected. So to answer your question, if some election litigation were to be commenced, and obviously I'm not in the business of advising whoever may be considering an election dispute, nor am I, going to provide that person or entity with some guidance on how to file some type of legal relief. But I am certainly prepared to advise the city and respond to any such legal claim that is brought against the city on the basis of the legal opinion that I've laid out to Mayor and Council this morning, and by way of my legal opinion last week.
So that brings clarity, that you have the authority to do it, and I remember reading that part. Okay. Got it?
Yes, Councilman Hernandez.
Yeah, Mr. Carter, I agree with you, all the way through that, you can't change the ballots, you can't do that. State law pretty much is to the point on that, I believe. The question again is whether at this point, whether they can run as a write-in candidate. Okay, and from what I gather, if you read the difference between partisan and nonpartisan, if it's a partisan election, you've got several different election groups involved, and you do not want to deny one of them the ability to go ahead and have a vote. That's what I understand. If it's a nonpartisan, there is none, so everybody is on the same deal, and so that supposedly there's not one party or another party that's going to go ahead and say, wait a minute, you did not allow me to have my vote, right? Am I correct in that scenario or not? Or give us an explanation as to what the difference is between partisan and nonpartisan. And because in one section here it did say that on 16.343 it says does not apply if it's nonpartisan.
All right. You're referring to the Catan opinion,
Right?
wherein the Catan opinion.
Even on 16-343, it states there again, does not apply to, pretty much, if you read the whole thing, pretty much kind of states that it doesn't apply as a nonpartisan, in a nonpartisan situation.
Let's try and bring some clarity to this issue again, Councilman Hanesian and Mr. Mayor. You're referring to the section in the Catan decision wherein it states, this is the third to the last paragraph in page 5 of the decision. It says, in Tejas, the solution to the death of the winner of the partisan primary election was his replacement by the county party pursuant to specific statutory procedures. Even assuming that it was proper to remove Bell from the ballot.
What's that?
Right here, right here. Go ahead.
Okay. And again, the Catan decision dealt with the issue of a councilman in Prescott wanting to be on a ballot. And he took it all the way up to the appellate court. And the appellate court wrote, even assuming that it was proper to remove Bell from the ballot, we find no authority or mechanism for replacing him with Catan or anyone else. Okay. They are making reference to replacing Bell with Catan, the person who brought the claim. And they are referring to a scenario that's laid out in 16343A4. If the vacancy occurs in the candidate race for partisan nomination in which at least one candidate of the vacating candidate's political party remains on the ballot for the vacating candidate's office, the vacancy shall not be filled. That is what the analysis centered on in the Catan decision, a partisan situation. The statute authorizing replacements in partisan elections, ARS 16343, does not apply to nonpartisan elections such as the one conducted by the city. That is where the confusion lies, because in that sentence, one would gather that 343 should be read to not apply to nonpartisan elections such as the one conducted by the city. But they are referring to 16343A4, where it specifically mentions if the vacancy occurs in a candidate race for partisan nomination. They are not referring to 16343D or E. That is to be read separately from 16343. And 16343 D and E are specific to the situation we are now dealing with, whereas they were dealing with someone wanting to force himself to be on that ballot.
But the last sentence there, Mr. Parra, is very pertinent, where it says the city charter does not contain any mechanism to replace one of the top 6 from the primary, and we will not create one.
That is correct.
You can take that to our city charter. Our city charter does not contain any mechanism to replace one of the 2.
And you're not replacing them. You're not. He's not going to be on the ballot. That's my legal opinion.
Right.
Okay?
But we have
But one thing is a ballot, and another thing is a write-in candidate. And this decision, I will repeat, and I highlighted it, we recognize that Catan qualified as a write-in candidate for the general election. Our discussion relates only to his eligibility to be listed as a candidate on the general election ballot.
And Catan wanted to be moved up to the 6th slot.
He wanted to replace Bell on the ballot.
As the 6th slot.
That's correct.
And we don't have any mechanism for that in our charter.
That's correct.
So then we go to state statute is what they did there.
Right.
So I don't know. I don't see anything else for us here besides cleaning up our city charter elections deal. So we have an answer there to submit to the people. Did you want to say something, Mr.
Are you done?
Yes, I'm finished.
Again, it comes really to a difference of opinion. Huh? To me, what I see here on the city charter, there is a mechanism. It's very clear. And someone's going to pick up on it. Somebody's going to deter from our opinion, or when I say our opinion, or the city attorney's opinion, the city body. And in all due respect for the charter, I believe that the answer lies within the charter. So I understand everything else that's been said about going forward with using state statute, and that would be correct if there wasn't a mechanism. Now the difference here, I guess, of opinion is I see that there is, and I don't know, there's a few that don't see that mechanism. So the thing is, that if it does go to court, then it will be reviewed, and they'll take everything in consideration, from the canvassing, the timelines, and according to the timelines, we have time to actually do a city election, but it would be costly. And I think that's what it boils down to, that we'd have to be probably acting on it pretty quick. And so, you know, still could be somebody out there that wants to challenge it, and we could find ourselves in court. And it's just going to be somebody else making the decision to try to override what we're doing here today. But you know, as far as I'm concerned, in respect to the city charter and what's written in there, that I see it clear. Everybody can read it over and over, and that's fine. Whatever your opinion or interpretation it is, it's you know, it's a personal interpretation, and that's why we rely on our city attorney to help guide us with that. But then we jump out of there and go, because we don't recognize, for some reason, the mechanisms that actually, where it says clearly here, that it goes back to making this general election with the rules of the primary election in order to make that nomination of the next person. So there will be 2 nominations in the general election. And it ties it in. 26 and 34 and 36 support each other in that sense. And again, how you want to interpret it, well, it's on an individual basis. So I just wanted to point that out the way I see it. And that's why I support the city charter. But it's convenient to me too to take the state laws, but I just want to make sure that I represent the city of Nogales and its residents and citizens based on the city charter. That's my opinion. But anybody, all of you have your own opinion, and I guess we're going to have to vote on this to approve anything, or just why did it say possible action then? What's the possible action?
I don't know, in case we wanted something.
That's correct, Mr. Mayor.
That was just language thrown in there.
Right.
Maybe that caused some confusion.
Yeah.
Because Mr. Catan originally in trial court, he won his case there.
That's correct.
And the city of Prescott took it to the appellate court, and in the appellate court is where the city of Prescott prevailed. Is that correct?
Right. Not all cases are the same.
Yeah.
There are some.
Right.
The fact pattern in the Catan case is somewhat different from our fact pattern.
Well, it's
And you know, but
completely different.
there is you know, obviously is to be taken in that manner, right?
Yeah, there's a lot of things there, like they talk about issuing a certificate of nomination immediately.
Mr. Mayor, I don't know if Councilman Hanesian had one last question.
Councilman Luciano?
What was the final conclusion of the League of Cities and Towns? Did they concur with your opinion?
The League of Cities and Towns provided an email, responded by way of an email, and assisted me with assisted me in my analysis. You know, I don't want to say that my decision is based entirely on the League of Cities and Towns decision, or on the basis of the Secretary of State's opinion on the matter. I can tell you that there was some concurrence with my opinion, and I did not receive anything in writing by any of my colleagues from the League of Cities and Towns that is contrary to the decision that I've now explained to mayor and council.
I want to take this moment, I guess here I'm probably one of the critics here, but I do want to thank you, Mr. Pat, that you didn't jump to any immediate conclusions over this. And who knows, if somebody takes legal action as far as wanting to go through the courts, they might see it your way too. And they might support you. But the good thing about all this is that you covered all bases. And that's what gives me a little peace of mind, that I don't see that you cut any corners. You did your due diligence, I think, beyond most city attorneys would have. Going that extra mile and checking with all these legal entities and agencies, and you know, from the League of Cities and Towns, from the Elections Board, from the Secretary of State, from I don't know how many. Apparently, you went through quite a few. And
Thank you, Mr.
I got to yield to them.
Thank you, Mr. Mayor. I do want to, express my appreciation to the League of Cities and Towns for having responded right away to my inquiry, to my inquiry on this particular issue, and also the responses from the League of, from the Secretary of State's office. I also want to thank our Assistant Chief and the City Manager for joining me last week when we met with Melinda Meek, as we, as some of these issues, we tried to flesh them out, and it is difficult because it is unprecedented. And some of you have worked with city government for a long time and have been in our community for a long time. And this hasn't really come up, but I do want to thank those two entities, the League of Cities and Towns. They really were efficient with their response, and so was the Secretary of State's office. So thank you, Mr. Mayor.
Thank you. And there's one more.
Just one more, Mr. Pata. This will set some kind of a precedent for the future. Here is the only reason that if a candidate runs. This kind of happened with Lieberman in Connecticut, where he was running as a Democrat and did not, after 3 terms, did not get the pick from the Democratic Party, so he ran as independent. Okay, I can understand that because again, he had different parties. But my question is, the only reason right now that we have write-in candidates is because Mr. Lucero resigned? Because my question is, in the future, let's say that, again, 4 people are running for the mayor. It's narrowed down to 2 people. Can the other 2 people say, well, first they're going to run as a write-in?
Absolutely not. Section 16312 does not permit write-in candidates that were not successful in being nominated at the primary to become write-in candidates.
So then the only reason it's allowed this time is because Mr. Lucero resigned?
That's correct.
And we needed a second person in there?
That's correct.
What about the 3rd person?
He's also allowed because he participated in the primary. That's correct.
So then people who did lose in the primaries are allowed to go ahead and actually run as candidates again. Not on the ballot, but can run as...
They can't, Councilman, unless there's a withdrawal, a death, or an incapacity of a candidate that was successful at the primary. That triggers the ability for that other candidate to jump back into the fold.
And whether we're partisan or not partisan had nothing to do with it.
That's correct.
Well, it seems clear enough. from the legal point of view. Is there anybody else that has a question or comment? From the council? No? Well, seeing none and there's no other further questions, I call this meeting adjourned. Thank you.
Thank you.